Hey all, here is a replay version of the most recent live stream Q&A on all things Social Security that occurs every Wednesday at 1 p.m. Eastern Standard Time. So this is with all of little silences carved out of it. So I hope it's an easier listen for those who are doing the replay versus being there live. And we'd love to see you live. So feel free to pop in. Bye-bye now. Oops, hold on. I want to do this. Hopefully this will work. I want to make sure. I just turned my headphones on a little bit late. I've been running all morning. Far away. So let me know if you can hear me. I am going to, oh, you can hear me. Beth, can you still hear me? Now that I put the headphones on and it's not, I'm going to assume you can. Okay. How are you guys? It's been crazy. Running down to Allentown, running back up. Okay. All right. Thank you, Beth. I appreciate. All right. Heads up about something coming up. I don't know where I am here. I'm looking at this. I'm looking at the YouTube schedule. As you know, we've had that. You might know the malingering. It's a 4-part thing. We put together, mostly me, and I had to break it up into multiples because I don't like to do more than like when I can, 10 minutes in a video just to keep them short. But it's like a 10-parter. Someone had asked about the function report when it comes to mental health claims when they're mostly or all mental health. The function report seems to be all about physical, but it's not actually all about physical. So I actually go through all the questions from a mental health claim standpoint on the function report. So if anyone wants to take a look-see at that, it's going to be coming out over the next probably 2 weeks, I'm guessing. The first one might be Saturday, and then they'll just be coming out as they may. But I just wanted to, and they will be called something like function report for mental health claim part 1, part 2, part 3. So they're easy to identify, and they will come out that way. So that's probably going to take up a bit of stuff, but anytime anything has to intervene, that is fine too. We can always pop a different one in, but just wanted to give you the heads up about that. Yeah, because even if it's not a fully mental health claim, you're going to want to know if for things that you might not have been aware of, how that is really affecting, because it might not be your back that's affecting it, but it might be some other impairment. So it was kind of geared towards those with primarily mental health claims, like oftentimes a younger person who the physical is never going to get them to where they need to be. And therefore sometimes they're sure that they are entirely mentally disabled from being able to do a full-time job 40 hours a week on a sustained basis. So it's all kind of from that perspective, but it's definitely equally applies to any mental health claim. Okay, let's get to it. Thanks guys for being here. And particularly when we're an hour later today, and that's because I had to take my son to the specialist appointment. So fingers crossed on that one. All right. So I did post up, I don't know if you guys can see it, the link for free evaluation if you wanted one. And then also prepaid consultation link for those that want that. We had one yesterday. Actually, it was last night. We just try to get those in really fast because when the people want to do that and they're spending money, it's usually they want it fast, like within 48 hours. So try to do that. All right. So let's see who's here. Half Pint's here. Hi, Half Pint. She says, hope you're having a great day. Yes, so far it's been just fine. Dolphin's in the house. That's RD. Hello from California. Hello there, Dolphin. Michelle's in the house. Good morning, Michelle. Beth, of course. Sindig. Great info. Thanks. All right. Well, glad to hear it. So if you have any questions, feel free. I'm not seeing questions, guys. So you're just going to have to give me something. I don't know where to even start. If there's no one with questions and you just want to chat, you'd have to give me a little bit of thought on what you want to chat about. I haven't even been in my email today because I left early. So I don't even know if anything new and exciting is happening in the Social Security Administration. I just don't know. Anybody? Let's see if I can find something. You don't really want to hear about old videos from the week, do you? No. Beth, right? The 15 to 20 days. Beth is referring to if you have gotten a notice that you have won your medical fight, and it says, now we must check the non-medical. And it says 15 to 30 days. That's actually the kind of non-medical review that is not fearful. Is not fearful like the ones where you have never gotten a decision or determination. You just get the letter saying, hey, it's back at the field office. We're doing a non-medical review. And then you don't know one way or another if you lost or won. And the fact that it was a non-medical review, common sense tells us, but it's not common sense. So therefore, this doesn't hold water, that you prevailed on your medical, because there would be no need for a non-medical exam for someone who is not found disabled, just as there's not a need for that for the 350 million people walking in the country just to check, hey, how's your non-medical doing? They don't have a claim. It's done. So I don't know why they send that out. But in the case where you have already gotten word primarily that you have prevailed, then the 15 to 30-day medical, non-medical is valid. They need to be doing it. And it's just to make sure you are double checking those numbers. Was she really insured at the time we found her disabled, or the adjudicator found her disabled? And other things like, is there a workers' comp offset? Or is there an alimony offset, or a child support offset, or a federal debt that you need to pay? Let's say you have back taxes and now you have a debt. Most commercial debts cannot be garnished or levied against your Social Security, but obviously federal debts can. Okay, that was Beth. Good question there, Beth. Jamie Scaval, good to see you again. Got my denial today. I knew it was going to happen because my lawyer put minimal effort into my case. He might have, but was it the kind of case that wouldn't likely win anyway? And when you say your denial, is that on initial or recon, James? James Kivel, I think I said Skivel. Sorry, James. Yeah, I mean, you need to find out. It usually has to do with your own proactive treatment. Your lawyer is there to do the legal argument behind it once he gets it. And I'm not defending your lawyer if you don't feel like you did a lot, but so much of it depends on what you did. Because remember, people do win sometimes without a lawyer, and it's because of their medical records. And if you don't have the goods that fills in all the factual spots in your claim based on your vocational profile and details, then that's the things you need to pick out, to find out. I don't know if you shared it before, James, your any details like age and all that kind of stuff, but I'm sorry you lost. If it is initial or recon, that's not unusual. So just keep pushing. And again, I know I had a video on this. People say, my lawyer didn't do anything. You don't actually know what your lawyer did because you're not in the office doing it with him, her, the paralegals, whoever. You really don't know the stuff that goes on behind the scenes because no one can hand feed it to you and then get the work done at the same time. Because remember, they're not getting paid when they do it. So it's got to be very efficient and concise. Okay. Thank you, Cindy. Cindy, is it Cindy G or is it Cindig? See what I'm saying, Cindy? Look at that spelling. Okay. Kevin Johnson's. Hello, Goldilocks. Morristown, Tennessee in the house. Hi, Kevin. Nice to see you. Michelle says, no new question, just waiting for adjudicator to be assigned in my case, waiting since 9/6. California is slow. Says on the Social Security site it takes 2 years for step 3 with an adjudicator. Yeah, I would hope not too. California's just got to hire more people in their state agency there. Half Pint says, I was under the impression that anyone who is approved will be able to sign up for Medicare, but I believe I saw something somewhere that you posted that said there's a waiting period. There is a waiting period. There might be one severe impairment or 2 or 3 that doesn't require waiting for Medicare. And I want to say it's something like ALS, like it's something that's probably terminal, not really, probably. And I want to say that's the one, but I can't say for sure because I haven't looked it up in a long time. But that one might not have a wait because there just is no time for that business. But yeah, we went over this last week. I don't know. I think you were here. You need to have received, constructively or otherwise, 24 months worth of Social Security disability, and then you are eligible for Medicare like the following month. So whether or not that happens during your pending claim, like your case takes 3 years and you win on the original date you said, they owe you 2 years and 7 months worth of benefits. That is certainly more than 24 months, right? And you would have been retroactively eligible for Medicare. And then, of course, they want you to pay for the retroactive Medicare coverage, which people get a little annoyed about because, let's face it, you didn't get to use it, right? But there's a reason why you still might want to consider allowing them to take the premium for those extra months, or all the months, I should say, out of your back benefits. Story for another day, though, right? James says, ALJ denied. I have to wait for the justification. Oh, yeah, so that's the decision. Yeah, and you'll see there, you're going to see in the decision, James, there is bolded, numbered paragraphs. Now, in between them is all the rhetoric that supports what that paragraph says up above. So you're going to want to look at the residual functional capacity that the judge found, and that is going to be where they say it's limited to light, but with blah, 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 or whatever it says, whatever limitations there are. So exertionally, non-exertionally, mentally, posturally, that kind of thing. Manipulative, and in between is all the meat of how the judge came to that conclusion. If the judge says it's an exertional level that you just think you can't win under the rules, if it is, because you could do light work or whatever, you're going to want to look at your evidence and say, how can I prove that I really can't do light work? I can only do at best sedentary work, right? Or if sedentary work is still you lose, how about, I get it. They're going to say I could at least do a sit down job, but I can't do it for 8 hours because it could be I have to go elevate my legs 4 hours a day because I have horrendous edema. It could be pain. However, that's because that's subjective. That's even harder to prove that you actually go do it because nobody's there to, your doctor doesn't see you. But if a doctor says, there's just ways to put the little crumbs in that aren't going to be a guarantee, but they can help. Like if every visit you talk to the doctor about my fatigue and the pain during the day, I have to go take like a 3-hour nap around 10:30 to 1:30. And if that's documented for years and there's diagnoses and severity described in the records that would support that need, maybe, it's really, really hard. It's so hard to prove that. You just have to do it through really aggressive treatment and communication with the doctors, and hopefully the doctors similarly communicate back to you in your records about that. But look for those things. And then make sure your dates are right. He's insured until so-and-so date. Your age, make sure they have your age right at the date of the hearing, that you didn't come close to the next age category, that kind of thing. Halfpint says the problem with medical records is that the doctors don't actually enter everything you tell them into your medical record. I have noticed. Yes, indeed. One of my big pet peeve mantras around here, right? It's true. And I know I've said this before, but it can be helpful, guys, to use, if they have a portal, use it for messaging your doctor. For instance, what about messaging him or her a few days before every visit to talk about, and you're not going to they don't give you that much space probably, although I've been known to do 2 or 3 in a row to get everything in. Not on any of my clients' cases, I don't do that. Although I'll help them if they want to articulate something. But for a friend I've been helping, because otherwise they had no way of knowing because she wasn't able to communicate. So you can message that. That's supposed to be permanently in the record as your communication. Now I know if you do the portal records, it's not going to show up. If just ordering your massive portal records, if you're under Epic or MyChart. Other ones, probably not either. But the official record set ordered by the SSA with the HITMER, or if you order them officially separately outside of the portal, then those messages are supposed to be in there. I think you could also fax a letter in each time beforehand describing what you really need to talk about, and talk about how you have to go get in the recliner because the back hurts so bad just from walking around and doing maybe 5 dishes and then, folding the blanket on the couch. And, next thing you know, it's starting to escalate. But if you send in messages, that's the way it might get in what your complaints are. And because it is true that when even the way they do it now with technology, where they're clicking on all the symptoms that you complain about, supposedly, it is often the default, I believe, is within normal limits or no complaints. So if there's 50 things they can click on, or you have 10 things and they don't feel like it, they might just pick the one and click on that, and that's only when you complain about that day. So that's really, really aggravating. Anything they put in their narrative, however, could speak more to it. And so if it's in one or the other, that's good. Particularly if it's in the narrative, I think it's stronger because it comes right out of the doctor's mouth. But if you at least have it that you complained, even though he doesn't address it later on at the visit, at least later on, some judge is going to see that you are complaining about this pain at every appointment, for every appointment, even though the doctor doesn't talk about it. But at least it throws a little monkey wrench in there, a little question, at the very least. Hi, Patriot Preacher. When you call to make appointment to apply for SSDI, what info do you need before the meeting? Well, when you call to make an appointment, you're not going to need any info besides your name and probably your social and maybe your birth date, basics like identifying things. The appointment would come at a later date. But honestly, I don't really recommend you apply on phone. I think it's one of the riskier ways to apply. Why don't you, Patriot, consider just going right online to ssa.gov and filing online there? Once you get a reentry number, which happens in the very beginning after you've kind of connected yourself in there, that gives you a protective filing date. So if you did it today and got just far enough to get a protective filing date, you don't have to put in all your doctors or anything. You print out that page, you save it. I save mine digitally, of course, to a PDF to my client's file, but save that. That'll let you get in time and time again until you get it submitted. It lasts for 6 months for SSDI. So that means if you're slow getting things in, you have more time. So it's helpful. Now, it is true, once you get past a different point, they consider you having applied, and that's before you put in your medical doctors. And at that point, if you submit it and you're tired, you don't finish it, they shoot you out a letter that says, now you got to do the disability part. Like, they don't even give you breathing space. I don't know why they do that so rushed like that. But I guess because technically the medical record stuff is not part of the application. It's part of your proofs after, so that the SSA can help you order them. Pardon me, I just got to tell someone I'm in a meeting. Yeah, so they will harass you for that medical information after they get the first part of the online application. And make sure you print, when you go to, every part of it has a summary page. Before you submit, if you ever see a submit button, go to the summary page and then print it. I don't know how you would do it if you're on a phone or whatever. I don't know, because I don't do it that way. But you want to know what all of your answers say. You don't just want to shoot it over there. It's also helpful if they lose it, if the system loses it. It doesn't happen a lot, but it does happen sometimes. You will have your answers and you won't have to like refabricate them. Same is true at the very end stage when you finally submit the medical portion of it. That's really helpful to have, because then you can look back and say, oh, I did forget to tell them about Dr. Jones. Let me go call once you get an adjudicator, let me call the adjudicator, make sure he or she knows that there's this other whole provider that we really want the records for. Makes sense. And for that whole online application, before you even start it, Patriot, the website gives you a list of everything you need. I just kind of blew through that, but because you're just going to need basically know when you stopped working, know when you became, in your mind, unable to work substantially. That number should not be while you were still earning some SGA income. It should probably be after that, generally speaking. And have a list of all your doctors, their addresses, their phone numbers. Personally, I like to have the facts. It's going to be better to get your records, but the SSA doesn't want that. Kind of know what you treat. They want your medications. So if you have your medications, have them out in front of you so that you can list them all and who prescribed. What else? Any tests that you can recall that were done, like diagnostic tests, blood tests, vision tests, MRIs, x-rays, CAT scans. They're going to ask about that. And a lot of times we don't remember those dates. So don't feel bad, guys. If you go in there and you go, I know I had an MRI in 2024. You can just be as vague as that. You don't have to know the date. Don't spend time calling your doctor's office to find out the details. They're going to be ordering your records. So don't kill yourself getting exact dates. I know they ask for it. It's on the form, but you don't really need to do that. And also, Patriot, if you're curious about what all the questions are, they do have paper versions of these things. The SSA 3368 would be the medical portion of the application. I want to say maybe -BK for whatever reason is I think that's the number for the paper version of the SSDI application. I don't recommend using the paper form. We're not even allowed to. The only time we can get away with it, and I don't choose to do it, it's more cumbersome work, is if their system's down. We got to get it out. Sometimes the system, on rare occasion, will not accept a person in their system for an application. And you don't know why, so you just got to do a workaround, do it the manual way. Hey, La Lulu, how are you? She says, a topic where clarification would help is nuances of how DLI date affects extended duration recon appeal or second hearing appeals. I have no idea what you're referring to when you say extended duration recon appeal. Do you just mean that you're in recon and it's taking a long time? DLA doesn't change. DLA has nothing to do with either of the above. It ends when it ends when it ends. It's all based on when you worked and earned the credits that gave you insurance out to a certain point. When you stop working, you stop earning those credits. Those credits are what represent that you paid the premiums. So like any other insurance, if you stop paying the premiums, eventually that coverage is going to end, whether it's in a month or a year or, however long you bought it for. So same is true with Social Security disability. And same would be, it won't change just because you're going to a second hearing appeal. They don't adjust that for you. But remember, if you're doing a second hearing appeal, and I think what you mean by that is you've been remanded by appeals counsel or federal district court. If that's the case, your DLI doesn't change, but you have now been allowed to go back to the ALJ who's adjudicating that time period before the DLI expired. You're getting a re-chance to prove that you were disabled based on the evidence back then. Of course, you can't add new evidence to that time period because it has to be born during that time. You can't have evidence today to say you were disabled 5 years ago. Right? As a by and large general rule, you can't do that. It won't work. You have to have the evidence back when it's kind of like how do you have a damaged car and you want to make a car insurance claim and the car insurance company says, we don't insure you. And you're like, well, you did back in, 2022. Well, that's true. We did, barring any time limit you have perhaps to make a claim. So prove to us that you had the accident in 2022 and you're covered. Why do I have to prove that I had the accident in 2022? She covered me in 2022. I mean, that's the same kind of esoteric thing. You have to prove that the damage occurred, the state of becoming disabled, back when you actually had disability insured status. Beth says, you haven't mentioned your metal detecting lately. Find anything good? How about I'm a complete loser with it, Beth? I need lots of practice. Yeah, I didn't end up having any luck. I did bring it to the beach back in the end of August, but I didn't find anything. And I did it very briefly, and I got impatient, and I really need to practice. It's pretty funny. I did watch some YouTube videos with it, though, and those are kind of neat. Michael Barry, 56 years old, no work history, back problems, trying to get on disability. Okay, well, I guess the question is, are you disabled or not, right? So is your medical evidence really strong, Michael? You have back problems. You might have other problems. You're 56, and you're just like my little brother out there. You could have arthritis, not just in your back, in your knees, your ankles, your feet. This is a bottom line rule of thumb. Consider chart. My clients know about my body chart. I think they hate it, but it does wonders. And look at every part on there and decide, is that part as good, strong, comfortable, fast, pain-free as it was when I was 20? And Michael, if it isn't, then there's probably age-related degeneration, and that's all you need. It doesn't have to be from some heroic act that you got disabled, and it doesn't have to be from work. In fact, it's kind of better if it's not work-related, but, do all the parts, not just the back problems. And if it is, whatever parts it is, you need current treatment today, very robust, updated diagnostics, MRIs, not just x-rays, they don't show squat, to show why you would not be able to do a medium level job. And you can't do a medium level job. You got to prove that. And that's lifting 20 to 50 pounds occasionally throughout the day, being on your feet 6 to 8 hours. That's another way to prove that you can't do medium work, is if you can't be on your feet that much. The other thing is, so you'd have to prove that you can't do your prior work. It sounds like you don't have any in the last 5 years. So that's easy. There is no prior work to have to prove against. And it can be easier at your age with the no work history. You just killed like 3 of the prongs or 2 of the prongs. So really it's whether or not your medical records are very aggressively obtained. Continuous physical therapies. If you're in a lot of back pain, obviously you're going to have some pain management, all those things. If you've not been doing that, just going to your PCP every 6 months and complain of back pain, you're going to lose. So be aggressive there, Michael. James says 52-year-old PTSD, fibromyalgia, back and nerve with MRI doctor notes. Appointments from treatment 3 times a week. It's crazy work. I'm obviously frustrated. I know you are. Fibromyalgia is a difficult one because it doesn't get a lot of emotional credit from the medical profession. I just don't feel like it does. It's one of those, some people believe it exists, some people don't. PTSD, I'm guessing they put you down, assuming you're treating for all these really aggressively, all these things you mentioned. I assume they said you were limited to unskilled work as a result of that. I'm guessing, but the fibromyalgia and the back pain, they probably said that you could do sedentary work. They might have said you could do light work. James, when you look at the decision, if it says light, they pushed you up to light, meaning you could be on your feet 6 or 8 hours and you could lift up to 20 pounds occasionally throughout the day. That's what they often do to the early 50s crowd, so that they don't have to award them by finding that they can only do a sit-down exertional for work. It's not that easy, but you have to really show how bad that back and nerve is. I don't know an MRI, that itself, if it's kind of moderate, might not show that you can't do a light job. You have to prove you can't do a light job, that you're far worse than that. It's not easy. It sounds like 2 to 3 times a week are going to medical treatment appointments. I don't know what kind. That would be either physical therapy or mental health therapy. But what about you were denied because of the RFC? I can almost guarantee it. You know what I'm saying? They put you at light or better. They could have even put you at medium. Depends on what really direct proof the MRI provided that it's just not, mild back issues. Okay. But I know you're frustrated, but don't give up. And hopefully keep an eye on your DLI, James, because it always concerns me when people, if they've stopped working and they've already lost once after waiting for ALJ, you might have eaten into your DLI at least halfway through. And that's if you filed originally shortly after, within a year after you stopped working. Pardon me. Yeah, just do the best you can. If you need to, if you're going to end up refiling, you have to make the choice of appeals counsel or refiling. It's a choice. It's kind of a tough choice too. Sometimes you have no choice but to go to the appeals counsel, particularly if you have no DLI left. But if you do have DLI left, you could make a choice, and you could, if you look at the evidence and say, I really should have gotten more in this area like the back. More updated diagnostics. You know, my diagnostic was 2 years old. Maybe now I have evidence of cord compression, or now it's severe stenosis versus mild, because that can make a big difference. You know, if that becomes the case and you want to talk about it, just reference that we spoke here, give your user name, and I'll have them send it over to me and I can go over that with you. Dolphin says, my mental health provider told me DDS just asked for my medical records 11/7/25. I'm in the process of appeal. Why didn't I get the records on initial? Probably because your doctor didn't provide them in a timely manner. That's usually how it is. Usually the requests are made and doctor just didn't send them, his office. I don't know which doctor this is or anything about it, but they generally ask for all the records unless they made a mistake. You can go in to see your, well, you can't, but your representative could go in and see the copies that they sent out and when. To the different providers, whether, you know, what the date was it on initial, was it on recon, and you could figure out if they requested it or not. And also, do you have a copy of your application? Are you sure that you put it on there for them to actually know about it? You'd be surprised how many people forget things on their initial, and then they're wondering why it wasn't in there in the end. Well, because you never told them. You know, that's another reason why we have everything in writing. Our people, as my guys know, all of our data forms, so we know what's in there, and we know what needs to go to the SSA. And the SSA, you know, if someone said that record, you know, why wasn't that in my application? Because you didn't provide it. See, Carrie says, is the application for SSI different than SSDI? Yes. I'm confused by the process. Handed it in person, phone interview next week. SSI requires a phone interview because they just need to go over things, because it's welfare and it's not insurance, it's not Social Security insurance. They got to go over your finances. They're not going to start up the expensive process of an adjudicator and all that medical records obtaining and CEs and all that if you're not even financially eligible for SSI anyway. So that's when they're going to find out the nitty gritty. Even though you put it down on paper, the paper doesn't really cover every little nuance. So they're going to want to talk to you about that, particularly your living arrangements. So because that affects what money you have available to you. You know, if your rent is being paid half by someone else, you know, particularly if it's a spouse or something. So, but I should go back, Carrie, and just say also that paper part is, and I think that's the SSA. It might be the 8,000. I always mix up the SSA 16 and the SSA 8,000. And they don't even put out modern ones. We always still use the old one because they never published them again. I guess they didn't like it when people did it. We do it all the time. In fact, we always do it. They have to accept it. Your medical portion is going to be exactly the same. So once you just get the applications in, remember I was saying before, the SSD application online, they really kind of trick you. It's actually, you get to the first, not in a bad way, but you get to the first part and submit it, and then it pops you into the medical. You're actually done with the application, but you have to get them the medical stuff for them to pursue it up at the, you know, the DDS. Same is true with the SSI application. In fact, what you can do, Carrie, which it's kind of probably water under the bridge now. If anyone needs to file for SSI, sometimes if you like doing things online instead of on paper or making a phone appointment or something like that. And again, I don't like the phone appointments, but you have no choice with SSI, Carrie. But for those of you, if let's say you know that you don't have SSD, you just know you're not insured for the time period that you need it for, and it's only going to be SSI, then you can go generally and apply for Social Security Online, SSD, like you normally would. And then there's a section where they ask, are you or do you want to apply for SSI? Something like that. Yes. And then continue on the SSD questions, get to where you submit that and you get to the medical input portion. You can get all your medical input right there. You don't have to do it by hand or on the phone and hope that the SSA person records it properly or doesn't get bored and stop listening and only took 3 of your providers. And you can get it all there and get your receipt that shows exactly what you said, you know, when you print out your review, your summary, I guess you call it. Then you want to nonetheless continue and make sure that SSI application gets in. But now you've gotten all the medical stuff in. And I think it's easier to do it online like that. And it's just more secure because you have proof that it went through the system. Just a thought. That's what I do for people who want to file for SSI. I wouldn't say we do it all the time. It depends. But if they don't have a pending claim, I'll do it that way. When you file for SSI, the SSA has to check to see if you're insured for SSD. You don't have to ask them to do it. They're going to do it because if you have SSD, that's what they're going to use to offset SSI if you win your medical things. And SSD is better by and large. So going that way is just fine. You just got to make sure you get your SSI application in, get ready to have a conversation with them, be amenable to all that kind of stuff. And at that point, your SSI application can be on the phone. Sometimes there's little flukes, like they will say the person isn't paying rent when they are. And you're like, but I told them I was paying rent. And because whether you're paying rent is going to make a difference as to the benefit amount you get. So, sometimes that's why I like things on paper. Proof of everything in every area of life. Beth says, regarding the portal, my main doctor likes it when I send messages on visits with other doctors and updates, since she uses that when I come in to remember everything that happened between our visits. That's awesome. And that is the way it should be, right? That really is terrific. I just had an appointment with my son, and he has to get referred to this other specialist. And then the original specialist, and it was being sexist here, guys, but it was a woman, and she was really, and that really doesn't make a difference, but she was so, because I've seen Weeachi ones too, she was so adorably sweet and she's a specialist. And she said, when you get done with that, let me know. So that'll be my cue to go check this. And we will have another discussion after this particular procedure and all this stuff. And I've never heard a doctor say that. Now, I've been using the portal messaging for years now with my children and now with my friend, although now it's kind of out of the outpatient doctor thing and it's more inpatient. But I did it largely so that if they're going to continue to slow walk treatment for my friend, there is going to be documentation that they were pushed and explained why they shouldn't. Because you never know where things are going to go. And I started in the end saying, listen, if this doesn't move where I think it should, I'm taking names and numbers. And this is what I told many of the providers, particularly I was saying it to ones that weren't even the bad slow walkers. But by then I was just so aggravated. And I'm like, names and numbers, I got them, and messages are going in, and they're not allowed to delete a message. So, and one could say, well, just because you're not allowed doesn't mean they don't do it. True, but now I think all the laws have that. It was under HIPAA, but it's about the inability to remove things, and it tracks everyone who goes in. Any, I would think they wouldn't even have access to delete something that someone else put in there, but there's auditing. I forget what it's called. I remember hearing about it it was like a HIPAA CLE I took, and I was thankfully relieved to know that I knew more than they did about the HIPAA and how it would apply to what we do, because it just seems like so many people, professionals, even don't know about it. All right, so James says, anyway, thanks as always for volunteering your time to help us folks try to navigate this maze that is SSA. You are welcome, James. It is, as you know, my pleasure, and my favorite day of the week is Wednesday. Although I guess it's next week. It's going to be Friday. Remember, guys, not having it Wednesday because I'm traveling. So I put it for the Friday, the day after Thanksgiving. Same time, 1 o'clock. Half Pint says, does SSA always call the person you list on your form as a contact person they can contact to ask questions regarding our case? Generally, they don't call. Generally, that is the person they're going to send the SSA 3380 to. That is the function report adult third party, the one that goes to a third party. It's basically all the same questions as you get in your function report when they demand that of you, but it is for the friend to be talking about you. Someone who knows you well, sees you. I think they have to kind of see you, particularly if it's for a physical impairment. Okay, Patriot says, told to make appointment for in-person meeting, not online. And you're talking SSI? That means it sounds like SSI, right? The SSI, Supplemental Security Income, Patriot, and not Social Security Disability Insurance. Because SSI, you have to have that financial interview, and that's all true. However, like I said, you can put your medical stuff in online. You don't have to choose to do it that way. To me, it's easier, but I do it all the time. But you're still going to have that SSI conversation, no matter what. And you didn't mention who told you to make the appointment. So if you were talking about SSD, who told it? Your brother, your mother, your neighbor? People always say, I was told. I'm like, by who? Might not always be accurate. Could be definitely best of intentions usually, though. Viv says, hi, Viv. I don't think we've met. 64 years now, filed for SSD, February 20 of 2024, I think you're saying. Denial in April of 2025, per grid rules. They found you could do medium level work, or they found you could do your old job, Viv. Currently in recon, completed new function report. Adjudicator got updated medical records today. Attorney got a notice if the claim is approved. Yeah, that's great. I'm very happy to hear that. Yeah, see, guys, a recon, flipsy. So the evidence got better. Maybe you had a durational problem before. Maybe maybe you hadn't been out of work a year yet, which can definitely lend itself to a finding that there's not enough evidence to show that you would be this disabled after 12 months. Who knows what it was, right? But good job. Good job, lady. That's awesome. Something to smile about. Beth says, don't forget to get your SSA statement before you apply. It's not available while you have a claimant process. To clarify, your estimate as what your benefit will be is not available after you apply. Your earnings statement portion is available after you apply. So you can always find out your historical earnings history. It's just the blanket number, the amount of income you earned that was taxed for Social Security. And that's important information that helps us determine the DLI. If we want to find it out really fast and don't have time to wait for the client to call the SSA and ask for their date last insured, we can kind of do the math on it once we see those numbers. But yeah, if you want to know what you're going to get for SSD if you prevail, get it now before you apply. I don't know how to say this. Is this Mitch Ken? I've been at disability for 20 years. I turned 60 at or on, I'm not sure. I turned 65 next month. Okay, so you're a young 64. Would it be safe for me to use my trial work period within the next 2 years to make extra money? Probably yes. Probably yes. Remember, trial work period is only 9 months though. Yeah, it's only 9 months. It could be, you could do 3 months of trial work period and then cut back to under trial work period. Around 1,100 to be under. 1,100 is close to trial work period. And then take a few months off, try again, trial work period amount, and maybe you'll never hit the 9 months before you hit full retirement age and flip naturally into retirement and no longer need to worry about disability. Just a thought. Ann Miller, occasional lift or carry 10 pounds. Lift and carry, they usually refer to it as. Frequently lift or carry, including upward pulling less than 10 pounds. Stand. Is this what they gave you? It sounds like this is what they gave you as an RFC. Stand and or walk with normal breaks about 6 hours out of 8 hours. So that's the light for walking. And they're saying you could sit long as well. Occasionally lift or carry 20 pounds frequently. Occasional, I'm not sure I'm getting here. So if it was sedentary, they would say no more than 10 pounds occasionally. That would be a sedentary limitation. No more than 20 pounds occasionally would be light. But here you say the frequent is less than occasional. See, that sounds like a light lifting overall. It sounds like they're saying if it's going to be 10 pounds, it better only be occasional. And if it's less than 10 pounds, you might be able to do it frequently. And that sounds like a sedentary lifting exertion. The walking business is putting you at light. So they can kind of fabricate some jobs that meet that. I'd like to think, depending on your age, and that could come to a grid out. It'll depend on your prior work history, of course, because you have to meet that prong also, as always. Sorry, I have to split my question. Is that RFC of light correct? Oh, okay. Being the 10-pound limit shouldn't be that light. That's what I'm saying. It's like your ability to walk is as high as lights, but the lifting is not a full range of lights. So you're kind of something less than a full range of light. Definitely sedentary, and some jobs that might be a little above sedentary. Do you know what I'm saying? It's one of those weird ones. I think the judge was sipping a little rum in his coffee that day for lunch. Just kidding. All right. Oh yeah, she said, shouldn't that be sedentary is what I meant to put. Yeah, no, I get your question. And I think you've got some merits to that. And it almost looks like it could be one of those, and these are kind of annoying in a way, but it's definitely better than if it was light. It's a better, more limited RFC than if they stuck you at late. So if you are between 50 and 54, you have hope. It's just not clinched necessarily, I don't think. What if there is any kind of writing about what if it's in between? It's not fully light, so shouldn't she win on the grid if she's 50 to 54 and can't do her prior work and has no transferable skills? Remember those 3 prongs? All right. Meow says, does testimony from a mental health specialist assist in a hearing? Depends what they testify to, doesn't it? Be very careful. I mean, normally we don't have our own doctors come in. I mean, unless you, like most PCPs and specialists won't do it. And if they did, they'd probably charge you $10,000. So you really better have your money ready. This isn't like a personal injury case where someone's going to win $1 million, so they don't mind putting out $10,000. Certainly your SSD lawyer is not going to do that. So, and it's your expense, not theirs. But you have to be careful when you're bringing, if your mental health specialist has stellar records, saw you a lot, there's no reason amongst the evidence to think he or she is mistaken or not a good, reliable, therapist, competent. Then those records just tell the story. You get up there on the stand and they question her about her records and she doesn't remember them, or she says one wrong word in a legal way, you just shot your case, potentially. So The beauty of the SSD program is that these records, which are not admissible in regular court, guys, if you had a personal injury suit or a medical malpractice suit or a products liability suit or premises liability case, you couldn't just bring in the records and say, see, this is how bad I am. No, you've got to pay that doctor to come in and testify. Thousands of dollars, because the records are out of court statements. They were made before, they were made outside of court, and nobody could cross-examine the person who spoke what's in those records, who expression is on them. There's no ability to cross-examine at all or direct examine. So that's, one of the major tenets of our court system and our legal system is that hearsay is therefore not allowed, because the other side can't even cross-examine it and question it and say, but you said this, but then you said this over here. They can't do that. So they're inadmissible. They are not inadmissible in SSD. Why? Because they know nobody's going to be able to bring in their doctor for their case. How are they going to, where is a disabled person who hasn't worked going to come up with, $40,000 to bring in all 4 of their doctors? That's assuming they only have 4. And now we have, like at any particular provider, we have a medical assistant who puts in stuff. We have a doctor, we have a PA, sometimes a nurse practitioner, sometimes an LPM. You could have 5 people for every set of records that you would have to pay to come in. So, and then it would be a whole day hearing at least. And the administrative process is not going to tolerate that. It's just not going to work. So the beauty is we get this unusual right of admissibility where we get to put in the records themselves. It is something to be very grateful for, because I used to do personal injury work on the defense side, a little bit on the plaintiff side, but mostly on the defense side. And that litigation is therefore extremely expensive, because you would have to, this is why those things all settle out of court too. No one wants to spend the $15,000 or the $20,000 on the specialist to have him come in and say, then he can read his records, and that's why cases just settle out. And also the defense would have to hire, pay their, as my old boss used to say, they're like paid hoes. So no offense to any doctors out there that testify. If you do it for a living, it's kind of, all right. So I just be careful, about, it's probably, I don't think I've ever had a medical person come in and testify. I've had a witness that has been a family member. I've had a witness that's been a case manager in a mental health case, and they don't charge you. They just come in. And that's maybe been 1 out of 100, maybe. I mean, most people don't have case managers either. It's really severe mental illness when it's like that, or inability to, it could be cognitive. Michael Berry says, thank you for the advice about the body chart, because I do have pain in my ankles and hips. Start working those up, Michael. Go to that hip specialist, usually an orthopedist, and then just talk about your hips and talk about your ankles. Ankles can greatly affect how much you can stand and walk. So, remember, light is like 6 out of 8 hours. That can limit you if you can't do 6 out of 8 hours. I also have something where I don't really do it too often with my clients, but the temptation is always there to get an accurate view of how long can you really stand in one position, say at a counter, Michael, not resting your arms, just standing straight up. How will you feel after an hour and 45 minutes, 2 hours? Can you do it? And then if you're allowed a 15-minute break, can you do it for another 2 hours? Then if you get another, say, a half-hour break, which would be akin to a lunch break, can you go back and stand there for another 2 hours? Another 15-minute break and another 2 hours standing. Would you be able to do that? Would you feel good? At what point would those ankles or hips start hurting you? And I'm sure you're back, right? Same thing with sitting in an upright chair. Never assume that sitting is in whatever chair you want. It's a work type chair. So that can be anything from a hard bench to a soft work office chair, but it cannot be a recliner where if you have to go be reclined to elevate your legs above your heart twice a day for an hour and a half to reduce that severe edema that happens when your legs are in the face of gravity underneath you. Ruby asks, what is DLI? Date last insured, Ruby? Date last insured. This DI is insurance. It's Social Security Disability Insurance. And like many term insurances, there is a date after which you no longer have the insurance if you don't continue to buy it. And that's what your DLI is. So for those of us that are still working, every quarter we get another credit. There's 4 credits to a year. It's like goes with the quarters. And so we're constantly always having the maximum quarters. It doesn't take a lot to get the max. This year you only have to work less than $8,000 that you pay taxes on, and you get all 4 quarters. But if you stopped working for a number of years, the general rule of thumb is for most adults, that's when you're younger. When you're under, I think 31, it might be a little less, but you're going to want to have 20 credits earned in the last 10 years. 10 years, you could feasibly have 40 credits earned because it'd be 4 quarters times 10, but it doesn't even require that. It only requires that you have half that amount. So, and because each quarter, I think this year it's $1,810 a credit, $1,810 per credit. You earn that and pay taxes on 4 times that amount. You got all 4. So very, very part-time work, even for like a non-high income earner. If someone can pull out, and that's under SGA earning those. So you're still not making so much that it would say his income alone means he's not disabled. So got to look at all those things. Keep that DLI way ahead of you. You want it to be definitely in the future. Carrie says, I own my own home. I think were we referring to SSI? I forget. That's always easier. And they don't count your home. So that's if it's SSI, not SSDI. SSDI, it doesn't matter at all. Oh, just making it so far. Well, that's a good thing, right? Had my hearing on November 14th. Still nothing from the judge. I wouldn't expect it to be that fast. I've never gotten one in 5 days. Today's the 19th. I have gotten one, I think, in 9 or 10 days, and that was once in 20 years. I have gotten a couple in 2 or 3 weeks, and most of the time it's a couple months. How do I know if I won my hearing? You don't know until you get the written decision. It's fun, right? If you have a lawyer, he might have an idea, because sometimes we can tell from how the judge set up his opportunity to make a decision. And sometimes the judge, the way he asked questions and received answers, the testimony does not allow him to do anything but that's not always the case, for sure. I love it when I see it, but I'd say more than half the time I probably don't even see it. And then you just got to wait for the decision. Patriot, SSDI, and I forget what you were talking about, Patriot. Let me just scroll up here. Well, then who told that to you? Who told you that for SSDI, you have to call them? That's completely false. I filed an application last night, like 11 o'clock at night, online. And I can even file an application for someone who's not yet my client. I just don't do it because I don't spend my time filing applications for people who are not my clients. It's not that I wouldn't do it for somebody. Like I do them pro bono, but usually then I represent them. Jasmine's in the house. Everything finally moved forward. I have a perk interview in 2 weeks. There you go. That's now that's after you prevailed, right? So this is where it was an SSI claim, guys. And now she's won her medical, correct me if I'm wrong, Jasmine, won her medical battle. That's the part that people like me are in the battle for. That's the part we work on. And now they have to do the financial question again. So are you still poor enough for SSI? And they go through all that income and assets questions, and living arrangements is really huge. Marriage is huge. Karma never. Nice to see you. Good talking to you this week. So Stephanie, thank you. If on SSDI at 62, since 59 and not due for re-eval for 7 years puts me at 67. What is the 62 there, Karma? If on SSDI at 62 years old, since you are 59, so for 3 years, and not due for a re-eval for 7 years puts me at 67. Well, no. Have you had a CDR? When he said re-eval, guys, I think he means CDR, continuing disability review. The 7 years would start at 59, usually. Like when you first get awarded, they have a diary. 7 years would put you at 66, right? I don't think they're going to give you a CDR at 66. You would have to do something overtly to make them want to do it, not just be breathing. Fair to say? Agree or disagree? Like when I say you have to do something, it'd be like you went back to work full time and they see that your salary from AT&T is, $100,000. They're going to go back and, I think so. Just don't do anything stupid, I know you won't, but just saying. Lulu says, yay to change of next week's live Q&A. Oh, all right, good. So yeah, remember guys, so Friday, the day after Thanksgiving, is the live stream for next week instead of Wednesday, because I will be traveling. Lulu says, I have 2 medical appointments and would have missed you. Aw, well, I'm glad. That's very sweet to say, although your medical appointments would be obviously very important. Plus, I don't have dollars to shop, even if Black Friday deals. I know, right? Save, save, save. I'm in such a save mode because, I just like to have security, I guess. I was so irresponsible as a younger person. Spent everything I made. Didn't make much, but I had to have fun. Now I have fun in more sedate ways. Thank you very much. Your statements are invaluable to me. Oh, meow. That is super sweet to say. All right. Carrie says, is it possible to get approved right away on SSI as I am 55, physical and mental health challenges. Yes, it could be fast for sure. It could be on initial. I mean, in theory, you could win within a couple of months. That's not very common because medical providers take a while. And then, there has to be, the medical expert has to look at it usually. But yeah, that can definitely happen. Make sure that you are making that physical and mental health treatment with diagnostics. If it's physical, bang, 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 make that your mantra. Just go, get updated diagnostics, go to physical therapies if reasonable to do so. And if your doctor doesn't, some people say, well, my doctor never mentioned it. Well, so what? He's half asleep on the job. You mention it and say, would this be helpful to me? I heard it might be. You got it. Sometimes some doctors, as my nurse sister used to say, and ironically could say this about the nurses too, but we never did. Half the doctors graduated in the bottom half of their class. What do you think of that? And 1 out of 10 graduated in the bottom 10th of his class. Maybe they never passed the boards. I don't know. Anne says, age 53, got denied at initial. I can't do 6 out of 8 standing though. In your medical records better scream that fact. Have tingling in foot from moderate to severe foraminal stenosis proven by an MRI 2 years ago. I don't get a lot of, and this is probably why you're denied maybe, a lot of traction from foraminal stenosis versus spinal canal stenosis. And I don't know why that is. I'm supposing maybe foraminal stenosis can be asymptomatic in some people. I'm not sure why it is, Anne, but how old are those? MRI 2 years ago. Those are old, babe. You gotta go get those updated. 2 years ago is too old. I mean, it's good, but think about what happens in 2 years at our fragile ages, Anne. The degeneration, spinal is usually degenerative. Degeneration occurs, and that might be a worse MRI now. I would go get one. I would work on that as a priority, and make sure you are complaining about the tingling. You have a neurologist, I presume, with regard to foot tingling. That's a big deal. There's something makes me think you have, and by the way, is that foot tingling newer than 2 years ago? Makes me think maybe you have some impingement due to maybe canal stenosis, or some nerve root exiting, something is getting pinched or compressed or touched. So I would get updated diagnostics amongst whatever else is appropriate. Hey, Jim Mako, how you doing, bud? Age 68 years young, wheelchair always denied. Well, you can't win at 68. I'm going blind, can't walk, living on $480 a month on SSI. Okay, so number one, there is no Social Security disability at 68. If you're on SSI only at 68, that suggests to me that you don't have Social Security retirement either. So maybe you didn't work during your lifetime. Is that a fair guess? Or if you did, you never made the 10-year minimum to get retirement. That could be it. Now, the fact that you make $480 a month on SSI instead of the $967 or whatever it is now suggests that you have other income coming in. Because even if it was just because you're getting free shelter from somebody, you're not paying rent, then that would still be up to $6 something. So you've got some other income coming in that is being the cause of the SSI offset. So if you think there is none, that there is no such thing, then there's something wrong. And that's something that you should look into because, in theory, you can get up to $967 plus a state, for many states. I don't know if it's all, but it's nearly all. If it's not, oftentimes SSI on the federal level, the states each choose to send you a check too. It's much smaller, obviously, but every bit helps, right? Yeah, I'm curious, Jim, what's going on with that? Yeah, at 68, but Jim, just know that you can't reapply for SSD unless you have not applied and lost at any later than, I want to say 66-ish. So if you haven't filed in a few years, it might even be 65. I'd have to do the math on the exact age, but there is no Social Security disability available once we are over our full retirement age, FRA. Dry air, guys. Can she talk? Pardon. Jasmine 1. But look into that, Jim, because it sounds like you should maybe get more SSI, if nothing else. Find out what's going on, unless you have some secret other income that you haven't told me about. Jasmine indeed had 1. Jim, you've been disabled since we were teenagers, huh? Or maybe you were, so you're like 10 years older than me, so maybe you were in your 20s. That's a long time. All right. So Jim is saying that his wife gets Social Security retirement. That is unearned income, part of which is deemed to you because you are married together. So that brings down your SSI because the united income is more than a certain amount. That would kind of explain that, Jim. That makes sense. Dolphin says, I was approved for a permanent disabled placard for neuropathy. Will that help my, when you say permanent disabled, is that for parking, Dolphin? Like you can drive, but you have this placard that allows you to park in the disabled parking lot, parking spot, so you don't have to walk as far. Will that help my claim? It doesn't hurt your claim. It doesn't hurt your claim. It could minutely help it. However, PCPs give them out to everyone with a non-full disabling job for impairments that make walking far distances difficult, but doesn't mean they couldn't do a sedentary job. So does that mean it depends really on your case as to how much that will help you. You're welcome, Jim. Ruby says, I have a very rare immune deficiency. Do I need to provide medical info for the people reviewing my case? If you want them to consider whether you have disabling immune deficiency. Yeah, Ruby, you knew this. When you applied, now did you apply it? It'll say, now you need to get us all this medical information. So you really do have to hop to it. They're not mind readers. They're not magicians. They don't have crystal balls. You have to get them all the information that's asked for, and they actually present you with what's needed. So you want to really be very proactive. Everything, Ruby. Pardon me, guys. The bird left a little bit of a mess. All right, guys. I think our questions are answered. No? Anybody else? Oops, we have Meow here. Meow says, will my attorney answer most of the questions at a hearing? No. He doesn't answer questions about you. You answer the questions. I'm afraid to answer as I have severe mental health issues. And you could be afraid. Just go and do the best you can. Yeah. Because remember, the hearing is about hearing you present yourself. You don't have to make anything up. They will ask you questions and you just have to answer them. That's all. It's not scary, I promise. Hopefully you're doing it with MS Teams from the comfort of your own home, and the judge will be, in front, and so will your lawyer, everybody doing it from, the MS Teams app. They'll ask you basic questions, name, address, make sure they have the right information, and then the judge may ask you some questions about your day-to-day, and your attorney will fill in with other ones if he thinks it's necessary, and there's nothing to be afraid of. I promise you'll do just fine. So he doesn't answer the questions. The judge wants to hear it from you. And that's a great opportunity. He'll see if you're anxious, Don't try to pretend you're not. Just be open and honest. Hey, George Graham. Hey, bud. Had to say hi. I'm so glad you did. I appreciate. Dolphin says thank you and have a wonderful Thanksgiving. You too, everybody, as well. Yeah, because I won't see you guys till after Thanksgiving. Yes, Lewis, just happy Thanksgiving. That's all I got. That's perfect. I appreciate it. And I appreciate you stopping in. That is super nice. Ann says, never seen a neurologist. Doc suggests another round of physical therapy. Also have CHF, chronic heart failure, congestive heart failure, I'm sorry. But somehow I have to prove this foot issue. Well, CHF, often people can do the stand-up jobs. They can do light jobs. They might not be able to do a medium level job. Or if the CHF is kind of mild, you have nerve problems. I'm not sure why you're not getting some of those nerve tests. Just saying. Things to think about and research yourself, do your due diligence. Yeah. Diagnostics to prove. There are diagnostics that can help prove that nerve is doing something ricocheting. I think you talked about it going down to your foot, right? Yeah, the foot is what can help prove that you can't be on your feet and are limited to a sedentary job. And I think at your age, was it 53 in? You have to prove that you can't do a light job. So the foot issue is very, very important. It sounds like your lawyer told you that, and I tend to agree. But the other stuff can help, and the neurologist can help. Half Pint says, oh no, I'm afraid of the hearing also because I struggle with memory. That's fine if you don't remember. And most of the time, a lot of times the ALJs will say, if you don't remember, I don't want you to guess or make it up. If you think you can accurately estimate, which requires some memory, by the way, then you could say, I can estimate, maybe it was about, but if you don't remember, you're going to want to say you don't remember for sure. Don't make stuff up. All right. I think we're good here, guys. What do you think? Any questions? I don't think so. We got everybody, right? Yeah, I think we did. All right. Ruby says medical journal articles. And that was about, let me just see what Ruby's talking about. Oh, I see what you're saying. Do you have to prove? No. They don't want to, you're not the expert and they're not going to, they have their own experts. So you don't have to provide, I thought you meant the medical records of yourself. Yes, that's on you. No, you do not have to be their doctor, professor, and teach them what the medical ailment is. They know how to do that. So you're good. You're good. And they have doctors. So Blue Graz says, love the videos. Oh, thank you, Blue. Just had my hearing, disabled vet, TDIU, PNT, some shoulder hip problems. I'm 54 years of age. Judge asked about, hypothetically, a 15%, assume you're talking about off task, and asked about medication twice. I said no, but cannabis is my fill. So you don't require any medications besides a little weed? Is that what you're saying? That might not bode too great. We don't have to take pain medications, and we're not willing to do the injections depending on the impairments and stuff. Sometimes, guys, and it'll depend on the case, but it can be optically viewed as, obviously the pain doesn't even get to a point where it's, oh my God, I have to take that thing. Like let's say you overdo it one day and you still don't have to take something. It's not so bad that you have to take something that you would normally not want to take. So just think about what that means. I don't know whether that affects or not. But you are PNT, you are 54, you say some shoulder hip problems. That doesn't sound very damaging. It doesn't sound bad when you just say, I got some. Maybe you're the one that underplays your pain, I'm guessing. Are you the type that just pushes through, blah, blah, the non-complainer type? Time to change that a little bit there, Blue. You have to be really honest about it. And you need to start pursuing the shoulder. Have you been doing the shoulder workup? What's causing the pain? Do you have a tear? Do you have a cuff? What's going on? And the hip problem, same thing. Maybe you have some arthritis in the hips, bursitis. You need to get into the specifics and get in there. Because at 54, we all got a little aches and pains, but most of us can work. So you have to prove why you can't. And you do have the grids on your side. And soon you're going to have the even better grid on your side. Fingers crossed, if you have bad results and I don't know if you have a representative or not, and you need someone to look at it for a possible new claim, feel free to reach out. Definitely put your screen name on so they know what we spoke about and they can confirm it. Michelle says, happy Thanksgiving, all. She's talking to you guys and me. Ruby says, yes, they have the medical records. Do they need? Yeah, sorry. I misunderstood you on that one, Ruby. They do not need the journal articles. Bluegrass says, I go to the VA for shoulder. It's bone spur. Okay. Well, keep working that up aggressively. What's the cure for the bone spur? Is that an option? Whether you do it or not, is it something that you would be a candidate for? All sorts of ways to just start kind of making that show. Is it very mild where it doesn't even affect your ability to do light lifting? Remember, at 54, you have to prove that you can't do light work. You have to prove that you're way more screwed up than that. So it's a high bar. You're welcome, Blue. Half Pint says, I have fluoroquinolone. Am I saying that right? Toxicity, also known as fluoroquinolone-associated disability. This just gaining more awareness. Will SSA actually research this? Yes, they will. They have all that stuff. Remember, they're the federal government, even the National Institutes of Health, they have full access to. Half Pint says, if not, how will they be able to make an accurate decision on my claim? They have doctors. We're not the only ones that have doctors, guys. They have far more access than we all have. So don't worry. Now, I think we've talked about this before. If they look at the diagnosis as being like a syndrome, like fibromyalgia syndrome, chronic fatigue syndrome, and the symptoms that are limiting and prevent work are subjective and not provable by objective medicine, that's a whole nother story. That comes down to, yeah, we think she's got we see she's officially diagnosed. We have to accept it. But then they kind of play down the severity of it. And that's where your risk runs, I think. Michelle says, Stephanie, I include you in the all. Thank you, Michelle. I will be supervising my husband as he tries to make the turkey. Yeah, my husband does the turkey too. One perk to having a disability, finding the positives. Yeah. Well, my husband's always done the cooking, and I'm not disabled. We always had that kind of flipped around in our house. But he likes to cook, and I kind of had the career when he didn't, so that's how it worked out the way. Now he has a career too, but I can cook, by the way. Thank you very much. I didn't marry him till I was in my mid-30s. I was cooking long before then. I taught him how to make a good Italian spaghetti sauce. He used to eat it out of a can. I'm not kidding. Jar. And I was like, no way, you cannot do that. Ruby, you are so welcome. Half Pint, you are welcome too. Thanksgiving to you as well and your family. I can't believe it's Thanksgiving. Oh, I know what I want to ask you. Just generally speaking, guys, who has real trees and who has that they cut down themselves versus you can get a real tree from a tree stand, supermarket even, versus an artificial. We always went and literally cut the tree down at a tree farm every year. I have pictures at the same farm since the kids were in strollers. Another 17 and 18. We bought an artificial this year. We did. We just bought it last weekend, actually. We talked about it with them. The kids seemed not to be really too concerned about the tradition of going to the tree farm. My son, particularly, because last 2 years he was the one that had to cut it down. But I'm kind of excited, and I feel okay about it. I'm like, if we ever have grandkids, if I'm still breathing by then, because I'm going to be an older grandma, then I think it's nice to have the tradition to start them off and get your great pictures of the great outdoors. But yeah, I'm kind of excited, and we're doing it for our own ease. We are the ones that set it up, get on our hands and knees. Is it balanced? I'm the one on the floor. And then one of my husband's biggest concerns is, and it's well taken, he's not here most of the days of the week. And if we miss a day of watering or it goes dry one day, you now have, supposedly, according to him, the tree can no longer suck up sufficient water to keep it kind of hanging okay till January. And he's really afraid of house fire. And I don't blame him. We've had like 4 or 5 house fires in the last 6 months in this development. I think some were arson questionable, but so it wasn't for Christmas trees, but I'm kind of just like, yeah, you know what? Let's do the artificial and we'll make some sort of tradition out of it. And maybe it'll be the day we all get together, decorate, and like go out to dinner or something. I don't know. And we used to always get it the day after Thanksgiving. When we first got married, we didn't have kids and we were both working driving to Jersey, and we got our tree the first few years like 2 days before Christmas. It was pathetic. And then we didn't want to take it down because we didn't get to enjoy it very much. So that's kind of different now. But all right, I digress. I was just curious about what people do, if they like their artificials. I think I'm going to love it. I think I'm going to be totally fine with it. I did decades of my whole life, and you guys know how old I am, of cutting down tree. And I think it's time. I'm not getting any younger. Does a composite job affect the grid rules? I'm over 50. Yeah, it can. It can even be to your benefit. A little too much to go into here, but yeah, I have things I would argue about composite job. Because, composite job largely has to do with whether you can do your old job. It's a composite job. Can you do your old job? So then you just have to look at the composite job and determine that. Remember, you have to make sure that you can't do your prior work. Half Pint says, artificial once the kids became adults. Okay, do mine count as adults? 17 and 18. Come on, say yes. She's already graduated high school. He's not, but he's the one that doesn't want to do it anyway. He's not the one that's really into that stuff. She's actually more into it, but she was okay with it. She's the one that's probably going to decorate the house. She already started. It was so funny. Michelle says, my husband proposed to me by his artificial tree he had in his room. So we put that up every year with our special chapel ornament. That's adorable. It's probably a tiny one, right? Or maybe not. It was in his room. It wasn't like up on a table or anything, right? That's really sweet. Hey, me, Heidi. Haven't seen you all day, right? Artificial 100%, she says, I ain't messing with all those needles and watering. Yeah, the watering, I have to say, I forget to water, and yeah, I think it's time. But I highly recommend real trees when we're young. I do. It's just so inspirational and stuff. And you are supporting your tree farm's existence. So if nobody needs Christmas trees anymore, they're going to go bye-bye. Michelle says, stop getting real trees when I spilled the water on the carpet and it stained. That too. You should see our hardwood floor. It's all buckly. It's nasty. I will have to admit that sometimes that might be because of some animal that did a mistake, but both counts, I think. Half Pint says, yes, that's about when mine didn't care to go to the Christmas tree farm either. Good, I don't feel alone. I'm going to tell my husband all this because it was really kind of like a guilt trippy kind of thing we were talking about. And because you want your kids not to be totally grown up, right? But I mean, we do, I don't know if you guys knew this, but one thing we do is my husband has been the volunteer Santa for 13 years, maybe 13. I don't know exactly, at the American Legion in East Stroudsburg, Pennsylvania. And it started because, well, he's a veteran, obviously, and he's an American Legion member. I'm in the auxiliary, not that I show up, but I pay my dues. And I'm the one that got them the volunteer Santa. They had a paid for Santa. Before that, it would cost them like $250. It was a Santa for the Children's of Veterans Christmas party. And I was at that time trying to go to meetings and stuff like that. And my kids were pretty young. So I volunteered my husband. He was so nervous. You should have seen him the first time. And then he'd have even his own kids sitting on his lap, and they were totally snowed. It was so much fun. It was really good. And then later on, after 10, you can't be a guest at the children's party. So we had to, one by one, there's only 2 of them, fess up. And then the way we put it was that dad's a helper. So you're going to be an elf for dad helping, and don't tell your brother and all that. And both of them were, when we had to divulge that dad is the helper, he's not actually, he represents the Santa at the party. Now we do it as a family. I'm Mrs. Santa. I have a I'll have to post a picture. It's funny. So we do it as a family. Santa basically hands out the Christmas presents, and the helpers, the elves, they're not really elves. They don't wear the ears or anything. They hand the gifts to Santa and say, this one's for little Mikey or whoever. And he hands it out. And last year, my kids each brought their significant others. Oh, no. Well, no, my daughter did. My son didn't have a significant other. But he has one this year. Fingers crossed. Still has a... Yes, how teenagers are. They're invited to do it too. They just have to wear like a green or red and, preferably a hat. But they can pick their outfit. It doesn't have to be matching or anything. All right, that's enough about that. Christmas is almost here, but Thanksgiving is coming first. So let's not give it short shrift. I love Thanksgiving. So anyway, thanks for coming, guys. I will see you next week on Friday instead of, oh my gosh, Ryan is a late arriver. Thank you, Michelle. Ryan, where you been? You're making me hang out longer than I was going to. How long does DDS take to start the process of reconsideration once SSA accepts the appeal? That depends on their backlog. I have a feeling that they have like a maximum that each adjudicator can have in their COIFR at any given time. So when enough scroll out so that yours gets a spot, sometimes it's right away. I have some that are within days, and then sometimes it's months. So it really varies on how well that state, I think, is supplying those state workers for the federal need. States vary in their skill set for budgeting and stuff like that. So anywho, are we all set? I hope that helped, Brian, even though it was not a defined answer. All right, kids, have a great week. Remember, just a reminder for those that you weren't here in the beginning, there will be I did a video on request for how to do a function report on mental health claims. Everyone always says, the function report is all physical. What about if mine is largely a mental health claim? So I actually went through it from beginning to end. It's kind of long, so it's broken up into like 10 segments that are each like 8 to 10 minutes long, something like that. It'll be named something like, they're not posted yet. No, they'll go up one at a time. Function report for mental health claim part 1, function report for mental health claim part 2, and so on and so forth. So you can definitely search for the name, and they will be in the function report playlist. I'm kind of tempted to just put them in their own playlists, maybe make it easier. I could put it in both, I suppose. Maybe I'll do that. Thoughts? All right. Feel free to comment anytime, guys. If you have an idea for a video that you think would be helpful to yourself and maybe other people, feel free to propose it, and I will give it a look-see and see if it's something that can be done without a lot of ado. I do ones with ado, but they have to be more planned because I need to carve out the time. If I have to do some extra research or confirm something that I haven't looked up in a while. All right, guys, I'm going to end it here. Bye now, because I'm going to cough.